Progressive, it's easy to reach customer service with our app, website, chat, or by phone. Because when getting help is hard, it's not help at all.
A little help. A little help over here.
Thank you for calling Bench Press Assistance.
What?
Due to excessive gym volume, all available spotters are currently lifting heavy weights off the chests of other bench pressers.
Seriously?
Please continue to hold, and we will remove the barbell from your chest in the order in which your cry for help was received.
Getting assistance should be easy. With Progressive, it is. Progressive Casualty Insurance Company and Affiliates.
You're listening to D.C. Judge Excoriates Trump Policing Surge, demands answers from Pirro, a news story written by Salvador Rizzo, and read by an AI-generated voice. A federal magistrate judge overseeing a torrent of cases during President Donald Trump's policing surge in D.C. condemned administration officials at a hearing Thursday, saying they were trampling people's rights by overcharging them with felonies and then moving slowly to dismiss the weakest cases while the defendants languished in jail. The blistering remarks by Magistrate Judge Zia M. Faruqui, a former D.C. federal prosecutor, were another sign that Trump's efforts to crack down on crime in the nation's capital are meeting extraordinary resistance in the city's federal courthouse. Grand jurors have declined to issue indictments on at least 7 occasions since the surge began last month, and Faruqui said federal judges would continue to push back on implausible, illegal, immoral prosecutions. Faruqui said the Trump administration's zeal to reduce crime in the nation's capital had touched off a constitutional crisis. Officials were playing cops and robbers on the streets of D.C. while the rule of law is being flushed down the toilet, Faruqui said. The message being broadcast to D.C. residents by charging people with federal offenses and then moving to dismiss the charges days or weeks later, he said, is to be afraid, be very afraid of the militarized forces roaming the streets. I am afraid right now, and that's not what this country is founded on, the judge said. What makes America great is the rule of law. It will not, on any of the judges in this courthouse, be broken down. In a statement responding to the judge's remarks, U.S. Attorney Jeanine Pirro said Faruqui has allowed his politics to consistently cloud his judgment. This is a judge who, by his own words, is trying to justify felons illegally carrying firearms in one of the most violent cities in America, Pirro said. He has repeatedly indicated his allegiance to those who violate the law and carry illegal guns, justifying the possession of these guns and constantly pushing for the release of these dangerous criminals back into our communities. The hearing Thursday had been scheduled to review whether a felony charge against Eduardo Dana, who was accused of making death threats against Trump last month, could proceed in federal court after a grand jury declined to indict him. But about a half hour before the start time, a prosecutor emailed Faruqui's chambers saying the felony charge should be dismissed, and that Dana, whose attorney said had long suffered from a mental health condition, would be charged with misdemeanors instead, the judge said. Pirro's office has also backtracked on other felony cases recently, an about-face after she had ordered her staff to seek the toughest possible charges for each D.C. arrest. In an interview on Fox News Sunday this week, Pirro said, "There are a lot of people who sit on juries, and they live in Georgetown or in Northwest or in some of these better areas, and they don't see the reality of crime that is occurring. And my office has been instructed to move for the highest crime possible, consistent with the law, the statute, and the evidence. But the grand jurors don't take it so seriously," Pirro added. Simeon Fontaine was charged last month with being a felon in possession of a firearm after D.C. police officers arrested him because he appeared to be unconscious in the passenger seat of a parked car that had an open tequila bottle in the back seat, a glass jar of suspected cocaine in the front, and a revolver in the glove compartment. Prosecutors then filed a motion to dismiss the case, which Faruqui granted last week. The U.S. Attorney's Office deserves credit for dismissing the case, Fontaine's attorney, Matthew J. Peed, said in an email. After the arrest, it became clear that the firearm belonged to someone else and was legally owned, and there was insufficient proof that the defendant knew about or possessed it. Torres Riley was charged with the same offense as Fontaine last month after officers followed him into a Trader Joe's and searched a crossbody bag he was wearing because it appeared as if a heavy object was weighing down the satchel, according to a police affidavit. Police found 2 handguns inside. Faruqui called it the most illegal search I've seen in my life, because wearing a bag that appears to be holding a heavy object is not enough to show probable cause that a crime is being committed. Pirro's office then filed court papers to dismiss the case. Mark Bigelow was arrested after officers approached a parked van occupied by 3 men and found an open container of alcohol in the row where Bigelow had been sitting. He was accused of kicking one officer's hand and another officer in the leg. Bigelow was initially charged with 2 felony counts of assaulting, resisting, or impeding federal officers, and he faced up to 16 years in prison if convicted. The U.S. Attorney's Office then dropped the felony charges and filed a single misdemeanor count of assaulting officers. Donisha Butler and Terrence Wilson were each charged with assaulting federal officers after D.C. police and federal law enforcement officers encountered an uncooperative and disorderly crowd in Southeast Washington. Wilson was accused of striking an officer with his elbow as the agents ordered the crowd to move back. Butler then tried to retrieve Wilson's sweatshirt from the police cruiser where he was seated after his arrest. An officer began moving her away and accused her of striking his face with her hand. Before the case could be presented to a grand jury, the U.S. Attorney's Office dropped the felony counts and filed misdemeanor charges of assaulting officers against both defendants. According to a person familiar with the case who spoke on the condition of anonymity because they were not authorized to discuss it, the felony charge of assaulting, resisting, or impeding federal officers has fared especially poorly before the grand jury since the start of the Trump surge. Grand jurors refused to indict Sidney Reed on 3 separate occasions last month. She was accused of injuring an FBI agent's hand as she protested an immigration arrest being conducted at the entrance to the D.C. jail on July 22nd. A grand jury declined to indict Sean Charles Dunn, a former Justice Department paralegal who threw a sandwich at a federal agent patrolling a popular D.C. nightlife area last month. Both were later charged with misdemeanor assault of a federal officer. Alvin Summers, who was arrested by U.S. Park Police after attempting to drive up a ramp to the National Mall, was charged with the same felony offense after his arresting officer fell while trying to subdue him, according to court records. The grand jury declined to indict him too. Prosecutors then filed court papers to dismiss the felony count. Dana's case started August 17th, when he was arrested on suspicion that he had pulled off a light fixture from the exterior wall of a restaurant. An affidavit filed in the case says Dana described himself as a person with intellectual disabilities to the arresting officers. He criticized Trump's police surge once he was in handcuffs. "I'm not going to tolerate fascism," he continued, according to the affidavit, saying he would protect the Constitution by any means necessary. "And that means killing you, officer, killing the president, killing anyone who stands in the way of our Constitution." Dana's public defender, Elizabeth Mullen, said in court papers that immediately after those statements, Dana could be heard on the same video loudly singing, "Baba Baran, Baba Baran." She asked Faruqui to dismiss the case with prejudice, so it could not be filed again, and to expunge the arrest, so it would not cloud Dana's record. "A 15-year-old would know that what he said about the president is not criminalized speech," Mullen said. "This never should have been brought in federal court as threats against the president," she said. Saying he was beyond outraged that the court was being used and abused to trample defendants' rights, Faruqui raised an extraordinary scenario. The U.S. District Court judges could soon stop signing complaints authorizing charges based on officers' sworn statements, he said, and instead call the officers to the stand to extract exculpatory information after an arrest. "This is not going to work. Complaints will not be signed. We're past the Rubicon," the judge said. The Justice Department's manual for criminal cases says federal charges should be filed only when prosecutors think the evidence can prove their case beyond a reasonable doubt, Faruqui said. The spectacle of filing felony charges that fail at the grand jury stage, or that prosecutors move to dismiss days or weeks later after more thoroughly reviewing the evidence, would only further erode trust in the criminal justice system, he said. A defendant with documented mental health issues, Natalie Rose Jones, had also been charged with making felony threats against Trump, which is punishable by up to 5 years in prison. A D.C. grand jury declined to indict her as well. Chief U.S. District Judge James E. Boasberg released her over prosecutors' objections, pending trial on any lesser charges. Faruqui dismissed the federal charge against Dana without prejudice, meaning prosecutors could resubmit it later, and asked the U.S. Attorney's Office to file court papers outlining its plans to mitigate the damage to defendants' rights from its erratic moves to overcharge and then drop cases. Separately, he set a briefing schedule on Mullen's requests to dismiss the charge against Dana with prejudice and expunge his arrest. If the arrest stays on Dana's record, it could change the arc of his life, the judge said. At the end of the hearing, the judge apologized to Dana and suggested the U.S. Attorney's Office also issue an apology. "I really appreciate the judge, though, for being reasonable," Dana said after the hearing. "I'm happy that this is over with." Pirro took the opposite view, criticizing Faruqui for past comments in a different case involving a charge of possessing an illegal gun. In that matter, according to Pirro, Faruqui told the defendant, "They said the worst thing a judge can have is they release somebody and they go out and they do something terrible. I don't think that's the worst thing. I think the worst thing is that I don't give you a shot." In D.C. Superior Court, Dana now faces 3 misdemeanor counts of threatening bodily harm against others and 1 misdemeanor count of destruction of property, valued at less than $1,000. Mullen said the D.C. Federal Public Defender's Office was stretched to the point of exhaustion. She said the office was in the midst of gathering data, measuring the time elapsed between the date of defendants' arrests and initial appearances in court. In an equally rare rebuke by a prosecutor of a sitting judge, Pirro said, "This judge took an oath to follow the law, yet he has allowed his politics to consistently cloud his judgment and his requirement to follow the law. America voted for safe communities, law and order, and this judge is the antithesis of that."